trial prep, and going to trial. If you've been charged with an offense, no matter what it is, at some point in time, you have to make that determination of whether or not you're going to go to trial or not. And we have a separate video on some of those determinations, right? Why you should decide whether to go to trial versus not. Some of those include you got a bad plea offer. The state has bad facts. There's bad evidence. Maybe witnesses aren't available. The consequences of taking a plea. So you have to go to trial. These are all determinations, and they're things that you need to discuss with your attorney. But when you make that decision that you are going to go to trial, the first decision is whether it's going to be a bench or a jury trial. In the state of Indiana, you have to preserve your jury trial right, especially for things like misdemeanors. You have to let the court know that you want to have a jury trial. So that's something that you need to think about. But if we assume we're going to a jury trial, then what are the next steps? What's going to happen? How do we prep for that? What does the trial actually look like? These are questions we get all the time. So the first thing we're going to do, if you say, hey, I'm going to trial, then we're going to determine who's going to be testifying at that trial. How many witnesses are there going to be? Is this a case where the only witnesses are going to be officers? Is this a case where you have civilian witnesses? Are there victims in the case? Who's going to be testifying? And what evidence might the state use? Is there video evidence they're going to show? Maybe they're going to play body-worn camera footage. Maybe there's video evidence that shows part of what is alleged to occur. Maybe there's video evidence that shows everything that's alleged to have occurred. Is there DNA evidence? Is there blood splatter? Is there, right, forensic evidence? Is there firearms evidence, right? Are there photographs of injuries? All of these things are things that we're going to discuss and figure out what's the state going to use. How is the state most likely going to present their case? And a lot of that is based on what you're actually charged with, right? And who will be testifying. And then in our preparation phase, what can we object to, right? Can we exclude some of this evidence? Is some of this evidence that they're going to try to use, is it not relevant? Maybe it's overly prejudicial. Maybe the evidence is too biased against you, right? For example, in the state of Indiana, the state can, at times, use prior criminal conduct at a trial. Maybe they're using it to show that you have a tendency to be dishonest, right? And so maybe you're lying about what happened. There are times that they can show that, but it depends on what were the prior criminal charges, right? Were you convicted of those, right? How long ago were those offenses, on whether or not they can introduce a prior. All of these things are things that have to be looked at and considered because you might have objections that can be made to them. There might be other things that can be done or other arguments that can be made to make sure that those things don't get talked about or this evidence doesn't get talked about. So we're also then going to determine what are the best arguments for trial. And it's a really important determination. The state has the burden to make their case. The state has to prove their case beyond a reasonable doubt. Arguably, you don't have to present any evidence. You don't have to make any arguments. You could sit there the whole trial and just have the state make their case and say they didn't reach their burden. But generally, we're going to make arguments. We're going to present a case ourselves, at least in some way, to give the jury an understanding of what really happened or to pick holes at what the state is saying, right? But we can also just make arguments. We can say, actually, this is what we're saying happened, right? For example, we could argue that you didn't do it, right? This wasn't you. That their witness is lying. Their witness is exaggerating. They're not telling the full truth. Maybe some version of the events happened, but what the state is alleging happened, that's not what happened. Maybe we argue you did this in self-defense. Let's say it's a battery situation, and they're saying that you hit them, right? And our argument is, no, this was self-defense. They hit you first. Maybe the argument is necessity, right? In Indiana, you have a lot of these things called affirmative defenses. There can be times where you can say, I needed to do something. Yes, maybe what you did might have been criminal, but you have what's called a necessity defense. Maybe you did it out of duress. That can also be another affirmative defense. These are all things that you have to consider. What arguments are going to be made? But also, you can argue in the alternative. And it's something that your attorney will talk to you about. For example, let's say that you've been charged with aggravated battery. And they're saying that you you stabbed someone, or that you took a bat and you hit someone, right? And maybe we can argue you didn't do that. Maybe the only person that's going to say you did that is the alleged victim. And we're going to say you didn't do that. Someone else did that. But we can also argue in the same trial, we can say the state didn't prove you did that. But also, even if you think that the jury thinks that you did do it, you did that in self-defense. And some people struggle with this idea that we can make arguments that almost go against each other, right? I didn't do it versus I did do it, but it was self-defense. But there can be times at a trial where that makes sense to do. Because maybe the evidence is going to be presented and we're saying, hey, look, we don't believe that the jurors are going to believe the evidence saying you did it. But we can also say that because of what the evidence has showed, it's clear that even if you did do it, this was self-defense or this was some other reason, right? These are all things that when you're doing trial prep, you have to discuss and you have to figure out. And specifically, once it starts getting close to trial, right, we're going to have conversations with you. Are you going to testify or not? We're going to explain to you what we believe as trial attorneys. This is our best line of defense. We're going to explain to you what our strategy is. How are we going to attack their case? How are we going to cross-examine the witnesses that they put forward? And we're also hopefully going to answer any questions you have at that time. Because for many people, they've never been to a jury trial. They don't know what to expect. They don't know how the trial is going to be. So then pivoting into that, what actually happens at trial? What does a trial look like? It's a common question we have when people decide to go to trial. They show up the day of and they say, hey, what is this going to look like? What do we do? What's all the steps? And so, generally speaking, for a trial, you show up the morning of. You're going to show up early, and we're going to have some discussions in front of the court. These discussions are going to include whether or not motions in limine have been filed, which motions in limine are things that we make sure the state can file them, the defense can file them, and we make sure that certain subjects can't be talked about at trial. Just certain topics are off limits at trial. We're going to talk about preliminary jury instructions, what the jury is told before the trial starts. Maybe there's other motions that have been made. Separation of witnesses, for example, might need to be addressed. Maybe there's some evidentiary rulings that we need to have before trial to determine whether or not certain evidence will get in or whether or not certain evidence can be used a certain way. These will all happen before the trial begins. And then we'll move into a process that's called voir dire. And voir dire is our jury selection process. And if you are the person on trial, you get to help us select the jury. And what happens is that the state and the defense, they get to ask the jury questions. We get to talk about kind of the subject matter. We get to ask them certain questions about their biases, their prejudices, right? And these can be important because maybe some jurors would be really good jurors for certain cases, but for other cases, they wouldn't be good jurors on, right? And this can also matter for a number of other reasons, right? Maybe they have a bias against certain religions or certain people because of the color of their skin. There can be a lot of reasons why we want to question the jurors and make sure that we think at the end of the day, they're going to judge the evidence purely on the evidence, and they're not going to judge or can find our client guilty simply because they don't like the way they look. Once the jury is selected, we move on to actually when the trial starts. And it starts with what's called opening arguments. The state will give an opening argument. We will give an opening argument. And the opening argument is, it's what we anticipate the evidence is going to show. The state's always going to say, we anticipate that the evidence is going to show X, Y, and Z, and we're checking all these boxes of what you're charged with. And our argument is always going to be different. Sometimes it's going to be, the state simply is not going to be able to make their case. You're going to have a lot of doubts at the end of this, and you're not going to be able to convict. Maybe our argument is, hey, our client's going to testify, and they're going to tell you that this happened, and that's what actually happened. But what we're going to do is kind of set the scene. We're going to kind of let the jury know where we're going. And then what happens is the state gets to present their case. They get to call their witnesses, generally, right? That's going to be the officers that were involved. It's going to be the victim if there is one. It's going to be civilian witnesses if they saw anything, right? They're going to make their case. They're going to present their evidence. We get an opportunity to cross-examine or ask questions of all of their witnesses. We are also going to have the opportunity to object as necessary if the state is doing something they're not allowed to do or they shouldn't be doing, or their evidence is something that we don't believe should come in. Maybe they haven't laid the proper foundation. Maybe it's irrelevant. Maybe it's overly prejudicial. Once the state closes their case, then it's our turn. In the state of Indiana and in the United States, you're innocent until proven guilty, which means that you never have to make a case. You have the right to remain silent. You never have to testify. You don't have to put on a case. So there are times that we're going to say, Judge, we're not going to call our client, right? The state simply hasn't met its burden. Their evidence, maybe their evidence is conflicting. Maybe their evidence simply they didn't have people testify to what they needed them to say in order to establish that you committed whatever they've charged you with. There might be other times when we say, Judge, we're going to call our client, or maybe we have our own witnesses that are going to give a different version of the event. It all changes case by case. And then after we present our case, we do what's called closing. And that's where the state and then us, we get a both make argument. The state's going to say, here's all the reasons why we've shown our case. Here's all the reasons why they're guilty. And we're going to then get a talk and say, here's all the reasons why the state is wrong. Their evidence didn't make sense. They had holes in their case. Their witnesses were all over the place. They weren't giving a cohesive story. Here's all the reasons why they didn't reach their burden. And then we're going to ask that the jury find you not guilty. And then what the judge will do, she'll read their final instructions and they send it back to the jury room. They deliberate. And hopefully at the end of the day, after however long it takes the jury, we walk out of there with a not guilty verdict. But that's what it looks like to prepare a trial, and that's what it's going to look like the day of trial. So if you have any questions, if you're facing criminal charges, if you're thinking about taking a case to trial and you want experienced trial attorneys, call us at 317-632-3642. And remember, always plead the fifth.